Hello, and welcome to the Parkinson's Foundation webinar, Navigating Long-Term Care for People with Parkinson's. I'm Donna Sperlakis, Senior Director for Community Engagement, and I'll be your moderator for today's webinar. Thank you for joining us today. The Parkinson's Foundation is a nonprofit focused on bettering the lives of those living with Parkinson's by improving care and supporting research. We work hard every day to ensure that our goals and initiatives are aligned with the needs and priorities of those living with PD. Today, we're going to explore available long-term care options, particularly when specialized care is important. We will discuss some planning strategies and tools to help you and your families make informed decisions that support your needs and long-term well-being. To begin our formal presentation, I'd like to introduce today's expert presenter. Lauren Fink is a shareholder with Mazur, Amundsen, and Baggio, PA. She practices in the areas of elder law and estate planning, which include helping to establish estate plans for clients, long-term care planning, asset preservation strategies, planning with government benefits such as medical assistance and veterans benefits, special needs planning, and probate and trust administrations. Lauren chose to become an attorney because her parents were caretakers for many elders in her family. She saw how difficult their job was and wanted the tools to be able to act as a valued guide for others who care for elders. I love that. Lauren's warm approach put her clients at ease as she helps them develop a plan, making sure they're confident about their situations and futures. Lauren, thank you for sharing your expertise with us today. I'll go ahead and turn it over to you.
Thanks, Donna. Good morning, everyone. My name is Lauren, and I am just going to share with you some learning objectives for what we're going to talk about today. So as Donna shared, I'll be speaking about long-term care planning and asset preservation strategies, and then also reviewing some of the government benefit programs that are available to help in paying for long-term care. So some of the objectives of what I want to talk about today is sort of an introduction to what elder law is and what the role of an elder law attorney is in long-term care planning, what some asset preservation strategies are for paying for long-term care. I want to review the eligibility criteria for the Medicaid programs, and I want to talk about what different long-term care planning options are available and what there are for recommendations for people that receive long-term care plans as well as their spouses. Before I get going on that information, I do want to give a disclaimer that when you are seeking information on planning for long-term care, it's really important to have an attorney, an experienced elder law attorney who's licensed in your state. Now, I am licensed in Minnesota, and that is the only state that I am able to practice in. So I've tried generally to make the information in this presentation apply broadly because many of the concepts that I'm talking about are from programs that are based on federal law, but there are specific things to Minnesota that may come out in this presentation that may not be true in your jurisdiction. I have provided a link on here for a attorney finding tool that you can use that is from the National Academy of Elder Law Attorneys. And that would be if you live in a state other than Minnesota and you're seeking an elder law attorney, I would direct you to use that tool in order to find someone who can help you with your particular situation. Long-term care planning is something that goes beyond just having your basic essential documents in order. So many times when we think about what attorneys can do to help us, we're thinking about estate planning, wills, trusts, powers of attorney, those different types of tools. And what an elder law attorney does is a little bit broader than that. So the the key with planning with an elder law attorney or with any time that you have a diagnosis of a condition that requires long-term care, such as Parkinson's disease, it's important to plan early to make sure that you have the most options available. So when you have a diagnosis, but your symptoms have not progressed to the point where you need long-term care, is a perfect time to begin planning, because then that's when you're going to have the most opportunities available for preserving your assets and making sure that we can create a good plan for the future. The goals in planning are not just to save your money or access different government benefit programs, but to make sure that you are living well to the very end, that you're living your best life possible. We want you to be able to preserve your own autonomy. We want you to make your own decisions at the time that you have the ability to make your decisions, and then provide that information to your team, which is the people that are around you, your attorney, your accountant, your financial advisor, and then your healthcare providers, in order to make sure that you get the best result possible. Planning is also about giving back to the people that you love, leaving a legacy and trying to make the tough times that may be coming in the future as easy as possible on your family members, because you've done proper planning in advance. Some common concerns that clients have when they are meeting with an elder law attorney are, am I going to have adequate or quality care? Am I going to be able to receive long-term care in an environment that I want to live in, that's not restrictive, that feels like my home? Will I be able to maintain mobility and control of my decision making? And do my family members know what those decisions are that I want to be made for me? What is the cost of long-term care? How am I going to make sure that I can pay for my care and not eliminate all of the assets that I have available? How do I not be isolated? How do I still continue to have visits from my friends and family members and not be locked away in a facility all by myself? And then what are the changes to my family dynamic? If you're married, your spouse may be acting as a caretaker, and how can we support them and ensure that things go, again, as smoothly as we possibly can? I give this definition here that's from the National Academy of Elder Law Attorneys about, again, sort of what the role is of the elder law practitioner. And again, it's a holistic practice where not only are we working on general estate planning issues and incapacity planning, but we also help with planning for long-term care needs, locating the appropriate type of care, and then coordinating your private and public resources to make sure that you can finance that care and ensure that you get quality care that you need. I talked about building a plan as part of something that you do when you are planning for paying for long-term care. And I wanted to provide you with just a list of who those trusted professionals are that are available to help you navigate some of these things that come up. So beyond the elder law attorney, your financial advisor is an important piece of that planning team. Your accountant, trusted family members, friends, and then your care providers all can kind of help work together to create a plan that will help you live and receive care. One of the areas of planning in elder law is called life care planning. And with life care planning, there are law firms that, in addition to having an attorney on your side for that elder law practice, also incorporate social workers. So my law firm is one of these life care planning law firms, and there's a nationwide life care planning law firm association where not only can we address the legal needs of the clients in terms of preparing estate planning documents and helping figure out ways to pay for care, but we can also address the issues that come up with our social worker in placement, access to care, problems that may come up in facilities, problems that may come up with home care. So to try to address all of the different needs of things that arise when someone has these long-term care needs. One thing that I like to talk about when it comes to paying for long-term care is this elder law care continuum. So this is kind of a good illustration where people who need long-term care don't go straight into a nursing home and that's where they stay for the rest of their lives. It's a continuum where you can see at the top, it goes from living at home to potentially adding in some in-home care or residing in an independent living facility, to maybe needing assisted living or adult day services, assisted living with memory care, nursing home, and then to passing away, death, which is true for all of us. And with that continuum, also your functional ability has a decline along the way, where those different care needs are addressed at those different types of facilities as you need more help. And you can see also that as those care needs increase, as the care level of the facilities increases along the continuum, the costs also increase as well. And so identifying as those costs are increasing, what are the different pieces of the puzzle that we can put together for paying for care? Private funds, veterans benefits, community service, Social Security, Medicare, Medicaid, and family caregivers. How do all of those things sort of relate into this long-term care planning puzzle? So the first piece I want to talk about in the puzzle has to do with what care options are available. And home care and care facilities are sort of the overview of items that I want to talk about. Home care options that are available range from PCA services, where you have a caregiver giving in who has a certification where they're able to help you with some of your activities of daily living. There's respite care, which is available for caregivers to take some breaks. Adult day programs are available where you can go to a facility for a set time frame, and there are group activities that are scheduled for to give again your caregiver at home some breaks. And then there's palliative care and hospice, which is the type of care where you're not treating the condition that you may have been diagnosed with, but you are treating the pain and the symptoms that you may have. Long-term care, there are options for residents such as continuing care retirement communities or CCRCs. And a continuing care retirement community is set with a goal where you can move into that facility and you can age in place. So these typically have what's called an entrance fee. The average entrance fee for one of these facilities currently is about $402,000. So it's kind of like buying a house. Only the house is located in a senior living facility. And then there are monthly maintenance or service fees that happen. And the monthly maintenance fees, the average, at least as of 2021, was around $3,500 per month. But the goal with these facilities is that you move in and you can remain there for the rest of your life. And you have that maintenance fee, or you may add on additional services depending on the facility. But they have not only independent living, but assisted living all the way up to skilled nursing for that entrance fee and those maintenance fee models. And again, these are different facility to facility. Some things that are nice about these continuing care retirement communities is there are a lot of socialization opportunities. So similar to some assisted living facilities, there's a lot of opportunities to meet other people at these continuing care retirement communities. Another option is assisted living, which is more like an apartment where there are care services that you can contract through a third party. These models kind of came around in the 80s and the 90s and were very progressive at that time. And the goal of these was just identifying that most people don't want to go into a skilled nursing facility. They want to receive care at home, but it is easier to contract that care when it's all under one roof. So sort of coordinating and conglomerating all of the individuals that need care together makes it less expensive, more convenient for the individuals that live there. In some states, Minnesota being one of those, there was also a moratorium set on opening more skilled nursing facilities. And so because we kind of hit the limit of number of skilled nursing facilities or nursing homes that we were able to have, we had to start adding in more of these assisted living facilities for people that have potentially lower levels of care. How payment works for these types of facilities is that there's typically a base rent amount that's paid for the unit. And then you may have a meal package or a medication package if you need assistance with the management of your medications. And then a service package, which the service package is quoted based on what your service needs are. So the higher that your care needs are, the higher the cost of your service package per month. Staffing in an assisted living facility requires that there be an RN or an LPN, generally available Mondays through Fridays, but there's typically not 24-hour staffing of a skilled worker like that available. One step up from assisted living is memory care facilities, which is a type of facility that, again, has specialized staff or training to deal with individuals who have diagnosis of dementia. I'm going to kind of skip past this. It's very similar to an assisted living facility, but with a little bit higher of a staffing ratio. And then some of the units may be locked to try to stop wandering or roaming. Residential care homes are something that is like a home setting where everyone lives in a house together, and then there are conglomerate living spaces like living rooms or kitchens or those types of things. And there are fewer people living in there. And then there are staff who are there who are available to provide care for those individuals. So it's a little bit smaller of a facility setting than an assisted living is, and it's a little bit more homey than an assisted living or certainly than a nursing home. And then the highest level of care is a skilled nursing facility. In a skilled nursing facility, formerly we call them nursing homes. They have staffing. Nurses are there for 24 hours a day, 7 days a week. So they are able to provide a much higher level of medical care at a nursing facility. And with a skilled nursing facility, typically for costs, there's a daily rate that's assigned for individuals that live there, which is based on a case mix classification. So they determine how much assistance you need, and then they assign the daily rate. And then that's the amount that you pay per day that you are at that skilled nursing facility. So the next question that comes up after we figure out what those sources are is, how do we pay for care? And one thing that I want to share with you all is a slide here that Genworth does a cost of care study every year. And the most recent numbers for the cost of care study I have listed on here. And I have national numbers, and I also have the numbers for where I'm located in Minneapolis. So nationally, you can see there's, care is pretty high depending on the different care levels that you have. So nursing home for a private room nationally ranges about $9,700 per month. And adult day, of course, is the least expensive option because you're spending the least amount of time there at about $2,058 per month. What the cost that you pay, though, of course, depends on the facility that you choose, where your own jurisdiction is. But most people with costs like this don't have the ability to privately finance or pay for care for very long. Pay sources for paying for long-term care. Privately paying is always the first source that we address. And privately paying may come from your income. But again, most people aren't making $9,700 per month in their retirement income. So then we're reaching into assets in order to pay for care. One thing to always be aware of with paying for long-term care is that there are some tax efficient ways to pay for care. And one of those is to be aware that you receive a qualified medical expense deduction. So the IRS for paying taxes, if you have care costs that exceed 7.5% of your adjusted gross income every year, then you get a deduction for all of those corresponding medical expenses. So there may be certain assets, such as IRAs, that make it more cost effective for you to pay for your care, and also more sensible to pass those assets on after you're gone if you have sufficient cash to pay for your care, where you can offset a distribution from a retirement account like an IRA with this qualified medical expense deduction. Some people may have long-term care insurance. Long-term care insurance is a particular type of insurance that you can purchase that insures against long-term care costs. But long-term care insurance, much like life insurance, has eligibility criteria that you need to meet in order to apply for. So with long-term care insurance, there are premiums for the long-term care insurance, and the premium might be cost prohibitive if you already have a diagnosis. If you already have a long-term care insurance policy, what you need to be aware of is that in order to collect benefits from that policy, many of the policies require that you meet certain criteria in order to qualify for payments. How that typically looks is that you need to demonstrate that you require assistance with a certain number of activities of daily living. Often with long-term care insurance, you have to show that you need help with at least 2 activities of daily living. Activities of daily living are things like feeding yourself, bathing, toileting, transferring, dressing, those types of things. The alternative would be too, if you have any cognitive impairment and you can demonstrate that you need substantial supervision, then that is also typically another eligibility criteria for long-term care insurance to begin to pay out. Now, many long-term care insurance policies have a waiting period where after you begin to meet that criteria to have those payments come to you, there's a 90-day period before those benefits will begin to take place. There may be a specific daily rate assigned for your long-term care insurance where the policy pays up to $200 per day, and it may have a total benefit amount of coverage where it pays for 5 years or it pays up to $250,000 of benefits, but it depends on what the coverage is that you've purchased. Many of these policies too also have inflation riders on them. The most common number that I see for an inflation rider is 5%, where every year the benefit that you have increases by that inflationary factor so that you can continue to have more coverage. With long-term care insurance, if you have long-term care insurance, it's a good idea to just take a look at that policy and see if it matches with what those care costs are that we reviewed from Genworth. Now, many people think that, oh, Medicare is going to cover some of my long-term care costs. And Medicare covers some, but not all long-term care costs. There are very specific time frames under which Medicare pays for long-term care. Medicare has some skilled nursing facility coverage to it, but the skilled nursing facility coverage only kicks in when you have a 3-day inpatient hospital stay. So you have been admitted to the hospital and you have stayed there for 3 days before you are discharged to a skilled nursing facility. And you have demonstrated that the care is reasonable and necessary. If that happens, then you can have up to 100 days of coverage, where for the first 20 days, there are no copays for the care. And for day 21 to 200, there may be a Medicare copayment of $204 per day, or there may not be. It depends on your Medicare coverage. If you have an Advantage plan or if you have a Medicare supplemental plan on top of your basic Medicare benefits. Medicare does not pay for care if you are at an assisted living facility, and Medicare does not pay for your care if you go directly into a skilled nursing facility without having that preceding hospital stay. There are also some barriers to Medicare coverage. One of those has to do with observation status. And what that means is that if you are admitted to the hospital, well, excuse me, you're not admitted to the hospital, you're taken in, but you are placed only on observation status, you're not admitted, then you don't get that Medicare coverage for up to that 100 days if you have to go to a skilled nursing facility after that hospital stay. So it's important to either know whether you're admitted or not, or whether you're on observation status if you have a hospital stay, and to try, if you know that there's going to be a skilled nursing facility stay after your hospital visit, that you are admitted so that you get that Medicare coverage for that care that you may need. Another barrier to Medicare coverage is I said that you can get up to 100 days of coverage under Medicare. And there has been a long-standing issue where if people are not meeting an improvement standard, so they're not showing that they're continuing to improve under the skilled care that they're getting, that their Medicare benefits will be terminated and that they will no longer pay for the skilled nursing care. There is a case called Jimmo v. Sebelius, which applies to skilled nursing care, home health, outpatient therapy, and inpatient rehabilitation hospital care, which provides that services can be covered and skilled as long as they're needed to maintain, prevent decline or deterioration, and that a skilled professional is needed to provide those services to ensure that they're safe and effective. So I just want to flag that for you, that if you ever have a denial for Medicare coverage because you're not meeting an improvement standard, that there is a court case that provides that that doesn't apply, so long as you can demonstrate that those services are needed and that a skilled professional is needed to get that coverage for you. And the benefit period, again, we kind of talked about that it's limited to up to 100 days. So if it's 100 days or more, then you may have additional coverage that you need. Medicare does have a home health care coverage benefit that I feel like it's not well known enough. So I always try to let as many people as I can know about this home health care coverage. How you can qualify for home health care under Medicare is if you have services that are ordered by your physician, that can be demonstrated they're reasonable and necessary, and that you are not homebound, or excuse me, that you are homebound. So what that healthcare looks like, you have to have a need for skilled care. So there's a difference between skilled care and custodial care. Custodial care is care that just covers your activities of daily living. So skilled care is a little bit of a higher level of care. And the care can cover up to 25 to 35 hours per week of skilled nursing and home health aid services. And it's not limited in duration. There's no copays or deduction, and you don't have to be hospitalized first. So this can be a really great benefit if you qualify for it. Now, if Medicare doesn't provide you with any coverage for the services that you need, then the other government benefit program that we talk about is the Medicaid program. And Medicaid is a jointly funded program by states and by federal government. So where the rules for the Medicaid program come from is from the Social Security Administration's Supplemental Security Income Program, or SSI. And each state picks and chooses basically what parts of that program they're going to apply to their own particular administration of the rules. And so that's why, again, I want you to be aware that these rules can be state specific, and I'll be giving kind of a broad overview, but some of the rules for your particular jurisdiction may be different than the information that I'm giving that's Minnesota specific. So Medicaid eligibility, it's a means tested program, meaning that you have to show that you meet certain eligibility requirements in order to qualify for the program. So generally, the requirements that you have to meet to qualify for Medicaid are that you have to be a resident of the state. You have to show that you meet what's called categorical eligibility. So in Minnesota, our categorical eligibility is that you have to demonstrate that you're blind, disabled, or that you're over age 65. You have to demonstrate that you require a skilled nursing facility level of care. And in Minnesota, we define that as needing assistance with activities of daily living or having a severe cognitive impairment. And then you also have to meet the financial eligibility requirements. Now, what Medicaid covers in terms of long-term care services is it covers skilled nursing care, it covers nursing facility care at an inpatient medical hospital, and it covers care at an intermediate care facility. There are home and community-based waiver programs that are created under the Social Security Act, usually under Section 1915C. And the goal of these programs is in recognizing that similar to the creation of assisted living facilities, most people don't want to go and live in a nursing home. They want to live in their home or they want to live in an assisted living, like a community-based setting. So the goal of these programs, these waiver programs, is to pay for care at those different settings so that people don't have to go to nursing homes if they can't afford their care. With waiver programs, 47 states and the District of Columbia are operating on at least one 1915C waiver. One thing that I think is pretty interesting about these waiver programs is that 53%, at least this was in 2014, I couldn't find a more recent statistic, 53% of all long-term care spending through Medicaid is on these home and community-based waiver programs. So the dollar amounts for that is about $80.6 billion per year. Versus other services, which are at 71.2 billion. So this is, this is big. These waiver programs are big. People don't want to live in nursing homes if they can help it. There's a map here that I want to share with you that came from CMS, the Center for Medicaid Services, that shows sort of where the states are that offer these different types of waiver programs. So you may see your state on here. The green ones are the ones that are the 1915C waiver states, and the sort of gold ones are the ones that have a 1915C waiver and a Section 115 demonstration, which is a type of program where they're kind of running a test setting of services that might be provided. The services that are covered under these waiver programs include adult day services, bath services, customized living, which is assisted living, chore services, residential care, homemaker services, home delivered meals, foster care, specialized equipment and supplies, environmental accessibility and adaptations. So some of the home and community-based programs that we have in Minnesota, individuals can make improvements to their homes. And improvements isn't really the right word. Modifications is more the right word, so that they're able to live at home for a longer period of time. So bathroom modifications are a really good example of things that can be paid for through a waiver program, where you can get a budget from the state that allows you to modify your bathroom so you can have a roll-in shower or those different types of things that you may need as your care needs change. So I want to talk about eligibility next, but some of the information pertaining to eligibility, I want to make sure that we're on the same page and just give you some terminology definitions. So when I talk about eligibility, I talk about a community spouse or the well spouse, who, if we have a married couple, it's the spouse who's living at home and who is not receiving medical assistance benefits. And I'm going to clarify, I will use the word medical assistance instead of Medicaid because in Minnesota we call that program medical assistance. So when I say medical assistance, I mean Medicaid. And I know it can be very confusing because there's Medicare, Medicaid, medical assistance, all of these different program names that we use that can be very confusing. Institutionalized spouse is the spouse who is receiving Medicaid benefits. So that is the one who requires long-term care. And with married couples, there's something that we have called spousal impoverishment rules, which are basically rules that were created by the federal government to, if we have an institutionalized spouse, so that the community spouse doesn't have to spend all of their money and be destitute in order to make sure that their spouse is able to receive the care that they need. So the eligibility requirements, when we look at qualifying for medical assistance financially, we have something called available assets or counted assets. And these are the assets against which the numbers for the program are applied. So an available asset is something that you have the legal authority and the actual ability to use that asset or convert it to cash. Examples of available assets are non-homestead real property. So typically the homestead is considered an asset that is not counted. But if you have a cabin property or if you have a timeshare, those are counted assets. So again, what that means is that the eligibility limit for the program that you're applying for counts that. And if that's above the eligibility limit, then it might be something that you have to sell and reduce before you're eligible for that program. Bank accounts, CDs, I'm not going to read all of these off to you. Retirement plans are something that some states count those and some states do not. So for example, in Minnesota, we count retirement accounts like 401ks or IRAs against the eligibility limit for the Medicaid program. But Wisconsin is a state where they do not count those as available assets for determining whether you qualify for Medicaid. Assets that are not counted include a homestead. There is a homestead equity limit where if you own a home and the value of that equity is above a certain amount, then it does count towards your available asset limit. There are certain exceptions to that, such as if you have a community spouse or a minor child who is living at that homestead, then that equity limit is not counted. But again, check on your state to determine which the eligible rule is for where you live. A vehicle is not counted. In Minnesota, the vehicle can be of unlimited value. So often clients may have handicapped accessible vehicles, which can be pretty expensive vehicles. And that is something that can be used to drive them to appointments, different things that they may have, and make it so that it's more accessible for them to get to those places. Pre-funded funerals are not counted as an available asset. So often in planning with clients, we talk about pre-planning for your funeral. In Minnesota, there are certain limits as to what you can pay for if you don't pre-plan for your funeral. So there are more availability of plans that you can have if you pre-fund your funeral. Some states exclude community spouse retirement accounts. Some states have wedding rings listed as an excluded asset. And some other excluded assets in certain states might be special needs trusts for the benefit of the applicant or the institutionalized spouse, or ABLE accounts, which is a type of account that can be created for a person with a disability, where the assets don't count towards that eligibility limit. Unavailable assets are assets that are reported but are not counted. So these are assets that there may be some type of legal hold preventing you from having the ability to sell the asset. So certain types of jointly held assets are considered unavailable. An example might be a cabin property that's owned by multiple siblings as joint tenants. If you don't have the legal ability to sell that by yourself, then that is not considered an available asset, but it might be available for estate recovery down the line, which I'll talk about. And then assets of an unprobated estate. So if you're going to inherit something, but you don't have a check yet, or property that's involved in a pending legal action. If you're going to receive a settlement, but again, you don't have the check yet, then that's not an available asset. So what the eligibility limits are that those assets apply to, if you are single, the maximum available assets that you can have is $2,000 or less, and that is state dependent. So in Minnesota, for example, we allow the single individual to have $3,000 or less. And that comes again off of that supplemental security income program through the Social Security Administration. The limit for assets for that program is $2,000. The institutionalized spouse similarly has that $2,000 asset limit unless the state increases it. And then the community spouse, depending on your state, there's a community spouse resource allowance that are additional assets that the community spouse can have, and that can range between a minimum of $30,828 up to $154,140, and that is jurisdiction specific. So in Minnesota, our state has accepted for the community spouse that they are allowed the maximum community spouse resource allowance, which is that $154,140. So that consists of all of the assets that the community spouse is allowed to retain, plus the assets that the institutionalized spouse can keep as well. So when we look at these different asset limits, and we talked about the different categories of assets, the available, the excluded, and the unavailable assets, if you have more assets than that, what do you do if you're trying to qualify for Medicaid and you have too many assets and you have long-term care costs? Asset reduction strategies, you may hear the word spend down a lot. I have to spend down my assets. Typically, the spend down is the income, what you have to do with your income when you're on that program, or at least that's how we refer to it in Minnesota. But what you're really doing is just reducing your assets to be within the program eligibility limits. So some quick and dirty ways of reducing assets would be paying for care until you hit that eligibility requirement. But you may have more assets than that there might be wise things that we could do, such as purchasing goods or services with those assets. You could pay a family member to provide care to you for a period of time until you would need to hire private care, until you would need to go to a assisted living or a skilled nursing facility. You can convert assets to income. You can transfer assets. But what the planning tools that we have, it really depends on the health of the person who's doing the planning. So your health, if you're not going to be alive for long enough for the planning to be beneficial, then it probably doesn't make a lot of sense. What the financial numbers are, sometimes if we have a client that we meet with and they have $15 million, then doing a plan to qualify for Medicaid probably doesn't make very much sense. And then what the overall goals are of the person. Some people really want to make sure that they're leaving a legacy to their children. Some people want to make sure that the community spouse is provided for and that they have as many resources as we can provide to them so that they're not limited to that community spouse resource allowance. So we want to look at those things to determine what the proper planning tool or technique would be. So purchasing excluded assets is a pretty quick and easy planning technique. With the homestead, we had talked already that a homestead is considered an excluded asset, meaning it doesn't count against those asset eligibility requirements, the $2,000 or the community spouse resource allowance of up to $154,140. If the community spouse lives in the house, it's excluded, it doesn't count. But that house might be not suitable for that community spouse to live in for the long run. So if they have a huge house that's difficult for them to maintain, that house could be sold and a new Rambler could be purchased. It's going to be a lot easier for them to take care of, or they could buy a condo, for example. Or if they don't have real property, but they have enough money to purchase a home, that would be one way to reduce assets, would be to purchase that house that's an exempt asset. The current homestead could be renovated or repaired. So many times we meet with clients who have just been scrimping or saving over the years, and they have a furnace that needs to be replaced. They've got a roof that needs to be replaced. They've got a deck that's falling off of the back of their house. And when we're otherwise going to have to reduce assets on paying for care, we want to make sure that that community spouse is living in a home that doesn't have all of these maintenance things in the long run to take care of when they're otherwise limited on the assets that they can have. And the key, though, with reducing by purchasing excluding assets is that there's estate recovery coming up on that. Sometimes you hear medical assistance or Medicaid referred to as a loan, that you're borrowing the money from the state now and it has to be paid back after your death. A vehicle is a way of reducing assets. So you can purchase a vehicle of any value, and you can purchase a brand new vehicle. So if you have a 1984 Chevy Nova, you can purchase a brand new car that is not going to have the repairs that might exist on an older vehicle for the community spouse. Household goods and personal effects are all excluded. So personal property, you can purchase tablets, televisions, computers, phones, different things like that. Sometimes clients will buy lift chairs or hearing aids, things that are going to make it so that they are have some comforts as they go into assisted living or into skilled care. Prepaid funerals are something that I mentioned, where you are limited on what you are able to do after you're on Medicaid. So prepaying for a funeral through a life insurance policy where you outline what the costs of goods and services are that you're paying for is a good way to reduce your assets to qualify. You can also prepay for expenses. So financial obligations that are due and payable, if you have homeowners insurance, real estate taxes, income taxes that are coming up, professional fees, accountants, attorneys who you need to hire in order to help with your planning. These are all ways that you can reduce your assets. Payments of debt, if you have outstanding loans, when you are on the Medicaid program, your income is limited. So you may not have enough income to pay off or to continue to make payments on debts that you may have. So eliminating those additional expenses is a good idea if you have excess assets. And then I mentioned earlier, payment of care costs is always an acceptable method of reducing assets to pay for care. Other things that can be done, you can purchase an annuity. So if you have a community spouse who has income that's very low, the institutionalized spouse's income might not be available to them after they're on the Medicaid program. So you can take excess assets and turn it into an income stream for that community spouse to make sure that they are able to continue to cover expenses that they have in addition to the resource allowance that they get. Annuities have to be very carefully managed. It's not any type of annuity. It's a annuity that has to fall under the rules of the Deficit Reduction Act, where it has to be actuarially sound. DHS is the Department of Human Services in Minnesota. They administer our Medicaid program. They have to be listed as the preferred remainder beneficiary. And there are other things that annuity has to meet in order to not count as an available asset or as a gift. There are also permissible transfers that can happen. So I'm just noticing that we're running a little short on time, so I'm going to quickly speed through some of these. Transfers between spouses are perfectly okay. So many times people are concerned that they can't change the title on assets between them and between their spouse, and that is permissible. It's also permissible to give to a minor or a disabled child as well. There's also a 2-year needed care transfer rule, where if a child lived with you for 2 years, the homestead can be transferred to them if you can show that but for the care that they provided, you would have to be in a skilled nursing facility that much sooner. Impermissible transfers or gifting would be assets that are gifted or sold for less than value. And there's no de minimis amount of gifting when it comes to the Medicaid program, unless it falls within a transfer exception. So if you have given something away, birthday gifts, holiday gifts, all of those different types of things, those are all transfers that count. And how that works is that there is a 60-month or 5-year look back period where if you apply for benefits within 60 months of having made one of these uncompensated transfers, then that has to be reported to the county, and then a transfer penalty may be imposed. The transfer penalty is calculated on all of those cumulative gifts that would have happened during that 5-year look back period. And the penalty is calculated based on a penalty divisor, which in Minnesota, our penalty divisor is currently $10,620. So all of those gifts are divided by that penalty divisor, and then that is equal to the number of months during which you would be ineligible for Medicaid to pay for your care. Now, one thing I want to show you all is that I have a chart in here that includes what the penalty divisor is in every different state. And the number, the penalty divisor is calculated based on the average cost of care in that facility, the state average cost of a skilled nursing facility. And the numbers are very different. I highlighted 3 of them on here. Illinois was one where I believe it had the lowest penalty divisor at $5,430 per month. And New York, of course, ranges very high and is also sort of jurisdiction specific, where if you are in New York City, then you're looking at $14,273 per month is your penalty divisor. So I have a gifting example here too that just shows a parent gave a gift to their child as to help pay for their wedding. They made another gift as a down payment on a home for one of their children. And then the parent had a stroke and is unable to return home. If that person applies for medical assistance within 5 years of having made those gifts, then those gifts are reported on the Medicaid application. They're divided by that penalty divisor, which I have the Minnesota one on here. And then there are 3.8 months during which, after the person is already eligible for benefits, that Medicaid will not step in to pay for their care. So what do we do if there has been gifting? You have the ability to wait for 5 years before ever applying for Medicaid benefits. There's the potential, depending on your state or your jurisdiction, for irrevocable trust planning if you have enough assets to make a large gift and pay for care for a 5-year period. You can privately pay through that period by using life insurance, or excuse me, long-term care insurance, or funds from friends or family if that's something that's available, but sometimes it's not. So, what I want attendees to just be considerate of is if you have been making gifts or if you plan to make gifts in the future and you have a diagnosis of Parkinson's disease, consider what the time frame would be of when you would need care and whether you have sufficient assets to pay through that relevant look back period and whether there's any planning strategies that would be helpful. Another thing to be aware of, I said that Medicaid is a loan that gets paid back after your death. Depends on your state. Some states don't have estate recovery, but what estate recovery is anytime that Medicaid is paid during your life, the state tracks all of the dollars that they're paying out for that program. And then on your death, that is placed as a claim against your estate. Some states have no estate recovery. California is an example of that. Some states have expanded estate recovery, such as Minnesota, where we also include revocable trusts, life estates, and non-probate assets as assets that can be claimed for estate recovery benefits. We have about 5 minutes left here, and I have some case studies, or we can go to questions. Donna, I know you are going to moderate some questions.
Yeah, we did get a couple of questions. Maybe let's just field a few of these more general ones. We could maybe prioritize a few if that's okay with you.
Sure, yeah.
Okay, great. All right. Oops, there we go. Start my video. So, just really quick, I want to just flag for everybody, if they didn't see it, my colleague did put in the chat where you can find an elder law attorney in your area. I think every time I hear these presentations, I'm overwhelmed by just how much information there is. And I think it's important to there's so much nuance from state to state. So I think, it's really important to find an expert. And I would say, Lauren, if someone couldn't find an elder law attorney, are there other types of professionals or other people who can help with navigating these types of questions?
There are elder law attorneys in every state,
Okay.
and many of them are able to meet remotely. Sometimes financial advisors would have information on it, but an elder law attorney is the only one that's going to have the qualifications to actually help implement legal strategies.
Right. So I guess then, just knowing that, like, obviously you never know people, you don't know when you're going to need this type of care. So if someone needs a starting point, what would you recommend if people wanted to start, whether it's organizing, the assets that they have, information, what are some good kind of starting points for people, just as far as like what they need to start thinking about or organizing and that type of thing?
Sure. So I think that at least, from my perspective, with a diagnosis of a condition like Parkinson's, one of the first things to start thinking about is that a time may come where you yourself are not able to make your own decisions when it comes to financial decisions or when it comes to healthcare decisions. And so the place that I always like people to start is by at least having a power of attorney and a healthcare directive in place. They're called different things in different jurisdictions. Sometimes you hear of a healthcare power of attorney or a living will, but those are documents that allow an alternate decision maker to come in and help you or make decisions in your place when you're not able to do it yourself. And what they do is they typically prevent any kind of court action from having to be taken in the event that you become incapacitated. So Parkinson's, I think, is a condition where there's so many different types of progression. You can't really anticipate whether there's going to be a cognitive effect or just a physical effect. But it's always a good starting point to at least have that document in place where if you are not able to exercise one later, then your family members don't have to go to court in order to help make decisions for you.
Mm-hmm.
And to that point too, Donna, bringing someone in to know where your assets are, where you have things, what your passwords are, if you have that trusted person, so
Yeah.
that if something happens and you can't give them that information, they don't have to try to figure it out. Because that can
Yeah,
be a
that's
really
huge.
difficult task if that planning isn't done.
Yeah. And I'll say, one question we often get, because I mean, the reality is not everybody has family, not everybody has, a close person. So for those people, what is the recourse for them? Is
Yeah.
there something that they can do, if they don't have family?
It's a good question. There may be friends that are, trusted or close friends who you're able to bring into the fold and help in that matter. There's also professional fiduciaries that can be hired, where that's what their job is. They act for people under powers of attorney or under healthcare directives, and they help with financial management and decision making, and healthcare decision making too. So those are people that may be available in your area. A good starting point to find out where a person like that might be would be to check with a financial advisor. They might have a referral, or an elder law attorney might have a referral for those different types of services as well.
That's great. That's great. All right. Well, we had so many good questions. I wish we could get to all of them. We are out of time. So, Lauren, thank you so much, for sharing your expertise today. And with that, I'm going to just share a couple of final thoughts for everybody, a couple closing remarks here. So before we close, I just want to share, and I don't know, did you know that you can include the Parkinson's Foundation in your estate plans? And if you'd like to do so, we hope you'll share this intent with the foundation. So if you would like to learn more, please send an email to legacy@parkinson.org, or you can visit this website here. Um, and also, again, thank you to Lauren for offering your knowledge, the time to share today with our webinar. And also a thank you to each and every one of you for being here today. Sorry we couldn't get to all of your questions. There's always so much information to share. And then finally, the Parkinson's Foundation provides weekly education and wellness programs virtually through our PD Health at Home series, including Mindfulness Mondays, Wellness Wednesdays, Fitness Fridays, expert briefings, and our Spanish language program. So please join us, find out more, and register for our PD Health at Home programs at parkinson.org/pdhealth. And please don't hesitate to reach out to the Parkinson's Foundation. We have a comprehensive website and many more resources available to address everything related to PD at parkinson.org. And of course, our helpline, which is staffed by Parkinson's specialists at 1-800-4PD-INFO. Alternately, you can email us at helpline@parkinson.org. So again, thank you all for being here today. We'll see you again soon. Until then, be well.